Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Oh, good morning. Welcome to the court's final scheduled oral argument of the spring term. It's the court's hope to resume in-person oral arguments in the fall term. We have cases to hand down this morning. Justice Baker. You're still mute.
Civil case number 2082, Stark Ligon as Executive Director of the Arkansas Supreme Court Committee on Professional Conduct versus Teresa Lynette Bloodman, Arkansas bar number 2005055, and original action. Petitioner's petition for contempt is dismissed. Special Justices Jeffrey Hatfield and Rebecca Blass join. Justices Wood and Wynn not participating.
CV-20-174 in the matter of the adoption of AMP and AAP. Rents Plymall versus Jeremy Allen Rogers and Brandy Nicole Rogers from Logan County Circuit Court, Southern District. Reversed and dismissed. Court of Appeals opinion vacated.
Will the clerk please read the submissions?
There are 9 appeals being submitted to the court for decision this morning. The first of which will be our oral argument today, Civil Case 20-536, Arkansas Department of Education and others versus Amber Booth McCoy and others, an appeal from Pulaski Circuit Court. We also have submitted today Criminal Case 19-901, Nicholas Lewandowski versus the state from Garland Circuit, Civil Case 20-682, the state of Arkansas, ex-rel Leslie Rutledge as Attorney General versus Purdue Pharma and others from Pulaski Circuit. Criminal Case 20-630, Freddie Clark versus the state from Pulaski Circuit. Criminal 20-690, Michael Eugene Rea versus the state from Saline Circuit. Criminal 21-15, Antonio Smith versus the state from Pulaski Circuit. Criminal 21-38, Bismillah Rahim Muhammad versus the state from Clark Circuit. Civil 20-698, Anthony L. Johnson versus Dexter Payne as Director of the Department of Correction from Jefferson Circuit. And Civil Case 20-725, Corellanius Phillips versus Andrea Culpepper, the Warden of the Cummins Unit, and this is an appeal from Lincoln Circuit. In addition to those 9 appeals, there are 14 other various motions and petitions being submitted to the court for decision today.
Okay, thank you. The case for oral argument today is Civil 20-536, Arkansas Department of Education and others versus McCoy and others. And the court will recognize appellant's counsel for their oral argument.
Thank you, and good morning, and may it please the court. I'm Senior Assistant Attorney General Kat Hodge-Guest, and I represent the appellants, the Arkansas Department of Education, and the members of the State Board of Education in their official capacities. Mr. Chief Justice, I would like to reserve 5 minutes for rebuttal. An adequate education has been both a constitutional mandate and focus since the founding of our state. Indeed, when considering all of the state's obligations, a suitable public education takes precedence over them all. And while adequate public education is a collaboration between the state and the local government, if the local government cannot bear this burden, then the state is required to act. In fact, it is never a rational basis to defer solely to local control if the ending result would be an inadequate education for Arkansas school children. Adequacy and accountability are the guiding principles in this case, which center on the state's lawful reconstitution of the Little Rock School District pursuant to the Arkansas Educational Support and Accountability Act. After 5 years of state control, the Little Rock School District failed to demonstrate that it met the criteria necessary to exit level 5 in need of intensive support. As a result, the state board adopted a reconstitution plan that authorized the election of a local board, but also placed limitations, three very specific limitations on the board's duties, limiting their ability to change the superintendent, make changes to the personnel policy committee, and institute litigation with the exception of contract disputes related to vendors.
Ms. Hodgegast, what you just mentioned is the state has been in control for 5 years, but yet we're still at a level 5 need. What do you contend that the Little Rock School District has to prove here? The state apparently hasn't done its job well.
Well, Justice Hudson, the Little Rock School District has an exit criteria that is in the record that demonstrates very specific outcomes that the district is required to demonstrate in order to show that it is no longer in need of level 5 intensive support. And the Accountability Act requires the school district to meet those outcomes with the state's assistance in providing support.
Well, when I read 2917, what I see is that the state board is required to annex, consolidate, or reconstitute after 5 years of state control. And time's up. Doesn't this mean that the state should step out of the picture?
Well, Justice Hudson, the statute does require the state to make a decision at the end of 5 years, and that is exactly what the state board did. They made a decision to adopt a reconstitution plan. Notably, that reconstitution plan provides for the election of a local board. The reconstitution plan is in the record. It authorizes the local board to make all administrative day-to-day functions in relation to the Little Rock School District, with the exception of these three very specific limitations. And so the board does have control over the Little Rock School District. What's important is in section 2917, Justice Hudson, the decision to reconstitute is made in accordance with the subchapter. And the board's authority is particularly established with respect to those school districts who are at level 5 in need of intensive support. And if you look at sections 2916 and 2917, the legislature has authorized the state board to take several remedial actions, including reconstitution, and to also include changing the makeup of the board and limiting those authorities. And so the limitation—
What would be the use of this timeline, this time limit of 5 years? The idea that what is going on right now as a reconstitution, I think, is left up to interpretation. I see the state has offered a couple of different definitions of what reconstitution means. How do those definitions really give us guidance here for deciding whether or not that is actually happening?
Well, I think that the key question is whether or not the board acted within its statutory authority, because the issue here is sovereign immunity, and that principle is well settled in this court. And I would point the court respectfully to its decision in Fitzgibbon versus Dory, and in addition to the language of the statute. And what the Fitzgibbon decision says is that the General Assembly has saw fit to give the state board or the Arkansas Department of Education broad authority when it comes to addressing deficiencies in our public school districts. Now, the Fitzgibbon decision involved fiscal distress. But
are you familiar with Harris versus Hutchinson?
Yes, Your Honor.
And in that case, we said that sovereign immunity is inapplicable in a suit seeking declaratory or injunctive relief and alleging an illegal, unconstitutional, or ultra vires act. And isn't that exactly what's being alleged here?
Yes, Your Honor, but this court made a further statement in Harris versus Hutchinson, and that is the court considers whether the facts alleged establishes illegal or unconstitutional or ultra vires acts such that sovereign immunity would not apply, and that whether or not a party is immune from suit is a question of law that this court will review de novo. And so the appellant's position is that the facts of this complaint do not allege unlawful conduct or ultra vires conduct because this court has already determined that the broad authority that the General Assembly has given in statutes like the AESAA do not constitute ultra-virus conduct. I mean, to rule
But
in
isn't that one of the arguments here by the appellees, that this statutory scheme in this sense is simply too broad?
That is their argument, but what this court held in Fitzgibbon is that the plaintiffs are asking this court to read limiting language in a statute, which this court expressly declined to do. This court could substitute the plaintiffs in this case and the statute in this case and drop it right into the decision in Fitzgibbon, apply the exact same rationale, draw the exact same conclusions, and reach the exact same decision. And that is, when the General Assembly includes a provision in a statute as it relates to public school districts that gives the state the ability to take any necessary action to remedy a deficiency in a school district, that discretion is broad. This court doesn't limit that language or doesn't read limiting language into the statute, and sovereign immunity prohibits those challenges, just like the ones the appellees are making in this case. In fact, if this court were to rule in the appellee's favor, it would be directly contradicting the holding in Fitzgibbon. The court would necessarily have to abandon that decision, and that's not even a position the appellees take in this case. In fact, they don't even address the Fitzgibbon decision in their briefing to this court. And so if you read the statutory language, particularly Section 2916, subsection K, in conjunction with the Fitzgibbon decision, there is only one conclusion, and that is that the complaint in this case, just like the complaint in Fitzgibbon, just simply fails to state a claim because it doesn't demonstrate unlawful or ultra-virus conduct, and it has to be dismissed with prejudice. Turning back to the board's authority to reconstitute the school district, I would also draw the court's attention to the Arkansas Constitution, which gives the General Assembly the authority to designate those officers who are responsible for supervising and also regulating executing regulations related to public school districts. And so because the Constitution, the Act, and this court's decision have all determined that these measures of broad authority are constitutional, then the circuit court erred when it denied the state's motion to dismiss, and the appellants would respectfully request that the court reverse that decision. Turning very quickly to the second and third points, appellees advocate for another exception to the sovereign immunity doctrine by invoking the Administrative Procedures Act. And the state admits that the APA allows for judicial review in very limited circumstances, which would constitute an exception to sovereign immunity, but they're limited in the issue of adjudication. But the appellees concede here that there has not been an adjudication. And so they try to backdoor or work around sovereign immunity by asserting that the state violated the APA when it failed to promulgate rules, and that just simply isn't correct. The record reflects that pursuant to 2917 subsection C2, the state board did in fact promulgate rules related to exit criteria. They were originally adopted in 2018. They were revised, subjected to public comment, approved by the Legislative Council, and have been in effect since January of 2020. What the appellees want this court to hold is that the state board is required to promulgate specific rules specific to the Little Rock School District under the APA. And the law just does not require that. For one, the APA defines a rule as one of general applicability. I mean, a set of rules that establish the criteria by which the Little Rock School District demonstrates that it meets the criteria to exit level 5 in need of intensive support is the antithesis of a general rule. It's a rule specific to only a local school district, and that's just not what the statute requires. to follow the appellee's argument would require this court to interpret that section of the statute in a way that the rules regarding statutory construction just don't allow for. And that is to take that one word, Article A, and interpret it to mean something that this court has held for at least 100 years means indefinite and non-specific. And so because the state has promulgated rules generally applicable to public school districts, then there is no exception to sovereign immunity under the APA or judicial review.
Counsel, is this really a sort of a nomenclature sort of issue that sort of between the two sides? So in a sense that this exit criteria, appellees sort of calling it exit criteria rules, and therefore saying it had to follow the APA, but the state is saying, no, the rules are the AESAA rules that were promulgated in 18 and then, amended and restated in 20. So, I mean, is this really what it's about, that the official rules were those, and then, the extra criteria, they sort of said, hey, then you can go, the exit criteria are sort of a supplement separate from the rules. The rules are what the statute required, but this is sort of, it feels like a little, everybody's calling it different things. Is that really what's going on here? Is just by calling it a rule doesn't make it a rule?
If I understood you, Justice Wood, calling something a rule does not make it a rule. I agree, and the statute doesn't require rules related to exit criteria. It requires the state board to provide exit criteria, but they're not identified as rules. The definition of rule comes directly from the APA,
and to be clear, the exit criteria, that was something set by the director, by Johnny Key, correct?
The Commissioner of Education, yes, Your Honor.
And so, but the rules were the Department of Education. So the statute that required rules, those were the AESAA rules that were statutorily required.
Yes, Your Honor.
And the appellee conceded in their brief that they have no objection to those, and they agree that those follow the APA, correct?
Yes, Your Honor.
Okay. And so then the issue is that Commissioner Key's, those exit criteria, but there is no issue about whether there was actual rules promulgated according to the statute.
Yes, Your Honor. Correct, Your Honor. There is no issue.
Okay.
I just want to turn very quickly to the third
Counselor, let me ask this, kind of follow up on Justice Wood. So what is your definition of guardrails? We've got guardrails, and then they're enumerated in three different ways. So what is the definition of guardrails, and how do those three guardrails apply to the education of these students in the Little Rock School District?
Well, the appellees refer to the three limitations as guardrails. I think that's language invoked by the appellees. But to answer your question, Justice Wynn, this court has answered that question also in Fitzgibbon. That was the same argument that the plaintiffs made in Fitzgibbon. The Pulaski County Special School District was under fiscal distress. The plaintiff said, what do these limitations imposed by the state board have to do with fiscal distress? And what this court said is they don't have to be related to fiscal distress. The state's discretion is broad. The General Assembly has authorized the state board and the Department of Education to best address deficiencies in school district pursuant to these statutes. And so respectfully, Justice Wynn, the three limitations, this court doesn't have to answer that question, and it already has if it's given this. That's not a reason to determine that the state's exercise of its discretion under the statutes is somehow ultra virus.
And then back to Justice Hudson's original questions about the 5-year period. And so it's my understanding the position of the state board is it was still up to the local entities to improve themselves and come out of the distress. And the state board was there to help them. Is that a fair explanation?
It is, Justice Wynn. The statute provides that the district has to demonstrate it meets the criteria. The state is responsible for providing support at various, depending on the differentiating levels of support needed for a particular school district.
Yeah. And so, and I know this may not be a question that you can answer, but so what did the state board, how did they assist the local entity in making these improvements? Because it obviously hadn't worked.
What did they do?
Yeah. I mean, what did the state do to help the local entity, get out of the distress? Because obviously it hadn't over a 5-year period.
Justice Wynn, you're correct. I may not be able to give you a sufficient answer to that question, but what I will say respectfully, Judge, is that the rules and the statute require collaborative effort between the state and the local school districts. And these improvement plans and exit plans are made in collaboration and communication and constant dialogue between the state, the Department of Ed, the state board, and the leadership. In this case, that would have been the superintendent. And I would just note for the record that the Little Rock School District's leadership, the superintendent, is not a party to this action. They haven't, the appellees are not the Little Rock School District leadership. They aren't the superintendent. They aren't a party to this action. And so, my answer would be that there is a collaborative process and a dialogue and an exit criteria by which the state works in conjunction with the school district to provide the support needed. And the school district is then required to demonstrate that it can meet that criteria.
Okay.
I see
Yeah, thank you. Thank you. I think you did a good job of answering what I wasn't sure that you could. So thank you.
Thank you, Justice Wynn. I am into my rebuttal time. I'm happy to answer more questions. If not, then I will reserve the remainder of my time for rebuttal. Thank you.
We'll recognize the Appellees Council.
Thank you, Your Honor. Chief Justice Kemp and Associate Justices. May it please the court. My name is Ross Nolan, counsel for the Appellees, the McCoy Group. This case is about whether or not the state enjoys sovereign immunity in its effort to control the Little Rock School District beyond the statutorily contemplated 5-year temporal limit. We ask this court uphold the decision below, denying the state's motion to dismiss on sovereign immunity, and return this case to the circuit court for a determination on its merits. The McCoy Group argues the state does not enjoy sovereign immunity on 2 grounds and an alternative third. First, the state enjoys no sovereign immunity for its illegal acts and extra statutory imposition of guardrails on the recently elected Little Rock School District Board beyond the 5-year limitation created by Arkansas Code Annotated 6-15-2917C1. Second, the state does not enjoy sovereign immunity for its failure to comply with Arkansas Code Annotated 6-15-2917C2 requirement to promulgate exit criteria for school districts under state control through an administrative rulemaking process. It is uncontested under points 1 and 2 that the state continues to impose guardrails beyond 5 years and chose to unilaterally create exit criteria instead of going through a rulemaking process. However, the McCoy Group's third point on appeal is in the alternative. Should the court find that Arkansas Code Annotated 6-15-2917C is written in such a broad manner, an interpretation the state encourages this court to follow, that it permits perpetual guardrails and unilaterally created exit criteria, then it must follow that sovereign immunity does not apply to the McCoy Group's cause of action seeking to declare Arkansas Code Annotated 6-15-2917C an unconstitutional delegation of legislative power in violation of Arkansas Constitution Article 4, Section 2.
Counselor, is a newly reconstituted district exempt from the AESAA?
No, Your Honor. Every day.
But when I look at 2 CV-20-536, I see that subsection B3B talks about limiting the powers and duties of a public school district in a situation just like this. So if this is a newly reconstituted district, why can't we look to these general provisions and moving forward?
I believe 2917 has to be read in sequence. If you look at A, B, and C together, it sets forth a plan where the state provides, or the district provides interim reports, quarterly reports to the state when it's under local control. And then in B, after 2 years, the state is supposed to begin to contemplate how to return a district to local control in that 2 to 5 year period. And then if that doesn't work, then you must move to C, which says if 5 years expire, then you have 3 options: annex, consolidate, or reconstitute. The Little Rock School District made it to C, to the 5 year cutoff. And the options there are clear. The state then chose to reconstitute the district. And that is the end of their authority to exercise control. But more importantly, the guardrails themselves are not contemplated by the statute, especially beyond the 5 year limitation.
Where does it say that, so reconstitute, if you look in Black's Law Dictionary, it says reform. Where in a definition of reform, reconstitute, does that say with no limitations? Where is that in the statute?
Your Honor, we're looking at 2917C that says after 5 years, there are those 3 options. And I understand
Right.
reconstitute is not defined in state law or in the rules promulgated pursuant to that law. But our contention is that there is a very specific list of things that the state can do to control a local school district, and that nowhere in this law is there permission or statutory authority to impose guardrails on a district after 5 years.
Well, counsel, would you agree that it's basically silent both ways? It doesn't say that they can place limits, but it doesn't say they can't place limits.
Yes, Your Honor, but one concept—
You're just asking us to read it your way.
Yes, Your Honor, but there is a construct of statutory construction when specific powers are listed that others may be excluded. And here the powers to dissolve the school board, replace a superintendent, engage in fiscal responsibility or fiscal discipline are all things that the state can clearly do under the laws that are created. And each one of the cases, Fitzgibbon, the Pine Bluff Dollarway case, the Decatur School District case, and of course the case initiated here at the beginning of this takeover, Key versus Curry, all involved districts at the beginning of their state takeover. That is a key distinguishing factor. The issue before you is new today. When does that state control end? Because those districts, the actions taken by the state there involved personnel decisions, involved removing the superintendent, involved removing the school board. Those things are listed in our statute, both the old one, the pre-2017, and the post-2017 amendment. So there is some consistency and things to be learned from those cases, but none of them address when it stops. And that's the key distinguishing factor between the present case and Dollarway, Curry, Decatur School District, and Fitzgibbon. So moving on, Your Honor, to the question of promulgating rules in regards to the exit criteria. We again rely on the plain language of the statute, which says the state board shall promulgate rules to establish exit criteria by which a public school district may exit level 5 intensive support. This language is not limited to or written in a manner to indicate that there is one set of rules applicable to all school districts or any school district. It says a school district, a public school district. Here,
Counsel, and you recognize the argument that opposing counsel raised is our case law, and we've recently said you're raising a challenge under section 214 But that says your challenge to the rules are the rules have to be generally applicable. But your challenge is you want a specific, you're upset that the Department of Education hasn't passed a rule exit criteria specific to the Little Rock School District. But because you're saying we want a specific rule, that means it's not generally applicable. So how, then you can't raise it under 214. What's your argument to that?
The argument is the very language of 2917C2 that I just quoted, that says for a public school district. It is specific to that school district. The exit criteria that the Little Rock School District is currently subject to were unilaterally created. You know, we cite and rely on the Monsanto versus Arkansas State Plant Board case and the Arkansas Department of Finance and Administration versus Carpenter Farms Medical Group cases as examples where post-Andrews that individuals have forced or challenged rulemakings pertaining to their interest before those boards, the Plant Board and the Department of Finance and Administration. So
right. Would you agree that we have dismissed their challenges when their challenge is not for a general applicable rule, but a specific rule to them?
Both of those cases succeeded, I believe. I am not specifically aware of a case that interprets the general applicability rule or interpretation that Ms. Hodge-Guest has cited. So we have provided instances where administrative rule making was determined to be the basis for denying sovereign immunity and proceeding with the case to determine what those rules or rule makings must look like before the agency outside of the sovereign immunity protections that would otherwise be applied post-Andrews to a legislative waiver of sovereign immunity. So again, we are relying on the plain meaning, the plain reading of the statute. We are not encouraging the court to go into statutory interpretation or construction because the language of the statute is clear. Exit criteria require a rulemaking process, including public notice and comment, the involvement of the community that is impacted by these decisions. That is the purpose of the Administrative Procedure Act and demonstrates the need of what public notice and comment could have done to improve the exit criteria and tailor them to the Little Rock School District and return it to local control, full local control in a more controlled and publicly transparent process. So I do want to, again, address some of Ms. Hodge-Guest's arguments regarding Fitzgibbon. It involved multiple class actions by teachers and staff. The circuit court granted a motion to dismiss on sovereign immunity in the case regarding the Arkansas Department of Education's control of the PCSSD for fiscal distress, resulting in employee terminations, both of staff and teachers and negotiating eligible employees. But again, those matters were all specifically listed in the statute as ways to address fiscal distress and to control the PCSSD or any district taken over by the state in the statute. Here, guardrails and the lack of exit criteria promulgated pursuant to a rulemaking process go beyond the statutory contemplation of the 5-year limit. So, Your Honors, again, for our third point is an argument in the alternative. The more power that the state claims under Arkansas Code annotated 615-2917, the clearer it is that their interpretation is accepted. 615-2917 is an unconstitutional delegation of power. The state's own brief claims that broad statutory authority and the ability to make any necessary and proper action allowed by law are part of this law and part of their powers pursuant to it. This amounts to indefinite control of local districts without the involvement of the legislature or new laws. Unbridled discretionary power without reasonable guidelines is unconstitutional. Similarly, absent appropriate standards by which the administrative body is to exercise its power, a law is unconstitutional. A statute which in effect reposes an absolute or unregulated and undefined discretion in an administrative agency bestows arbitrary powers and is an unlawful delegation of legislative powers.
Counsel, can you tell me where on page, I see in your unconstitutional delegation of power in your complaint, I don't see that you cite a constitutional provision that you say is violated. Can you tell me if you cited that in your complaint?
I believe so, Your Honor. We are making an unconstitutional delegation of power argument under Arkansas Constitution Article 4, Section 2, which states that no person or collection of persons being one of these departments shall exercise any power belonging to either of the others except in the instance hereinafter expressly directed or permitted.
Did you plead that?
I believe so, Your Honor, but I do not have the complaint immediately in front of me.
Counselor, is your argument similar to those made in our recent Arkansas Plant Board cases in terms of the broad statutory authority granted in this instance?
I believe Arkansas State Plant Board versus McCarty is particularly applicable to the unconstitutional delegation argument that I was addressing now. And then the Monsanto versus Arkansas State Plant Board is particularly applicable to the promulgate rules argument that we've made today. But yes, as a whole, I believe both inform the arguments and decision that will have to be made here today.
Thank you.
Counsel, if you failed to plead that, did you amend that at any point?
We have not amended our complaint. It was we came on appeal very quickly, but I do believe it is labeled unconstitutional delegation of power as a cause of action, and then of course we have briefed it below.
Okay, but I mean, if you neglected to actually list a constitutional site in your pleading. Okay, thank you.
Thank you, Your Honor. One more matter that I would like to address is Ms. Hodge-Guest has discussed in depth in both her brief and her oral argument today the concept that adequacy and the state's obligations under Lakeview and the Constitution play into this case. It is our contention that they do not. There is no ruling on those concepts from the circuit court. The issue solely before the court is one of statutory interpretation and whether or not these statutes require administrative rulemaking for exit criteria, permit guardrails to be imposed, and if they do, whether or not that is a constitutional delegation of power. So again, Your Honor, adequacy is not before the court today. It's a much simpler question of sovereign immunity and what is required of the state at the conclusion of 5 years. The McCoy party presents alternative arguments challenging the state's continued control of Little Rock School District through the imposition of guardrails and unilaterally created exit criteria. The state either exceeds its statutory powers or the broad and definite control of local school districts the state claims is an unconstitutional delegation of power. It is one or the other. We ask the court to uphold the circuit court's ruling denying the state sovereign immunity and permit this case to proceed to a decision on its merits. Thank you, Your Honor.
Counsel, you say that adequacy is not an issue here, but isn't adequacy kind of the constitutional umbrella under which all of the educational issues have operated for the last 19 years? I mean, you're making some local control arguments with these guardrail arguments and things of that nature that feel very much like pre-Lakeview arguments, and we're living in a post-Lakeview world where this court said that the Constitution requires and says that it's not only the right of the state to provide, but the responsibility of the state to provide the general, suitable, efficient system of public education. And the adequacy umbrella seems to kind of be over all of this. And so, you know, in the Lakeview, the post-Lakeview world in which we find ourselves, you know, the state, whether you want to call it guardrails or training wheels or whatever you want to call it, the state seems to be the one that carries the burden of making sure that a constitutional system of education is applied.
Yes, Your Honor, absolutely. But we still have statutory law that is interpreting and governing that power. And the state has to be bound by that to some degree. Otherwise, there is an unconstitutional delegation of power. And those statutes read clearly to appellees, and we hope they read clearly to the court that, you know, there is no statutory basis for continued guardrails beyond 5 years. Does that mean that the state could not continue to provide support to the Little Rock School District? Of course not. Every district in the state receives some level of support from the Arkansas Department of Education. It is a cooperative operating relationship between all the districts, but there is still state law that puts some limits on that control. And it's our contention that there is no authority to impose guardrails, and that if you are going to create exit criteria, that they must be done pursuant to a rulemaking proceeding where the public may be involved.
Thank you.
Any other questions? If not, the court will permit rebuttal for the appellant.
I apologize about that. My camera's not following me. Your Honors, I want to start with the unlawful delegation argument because I didn't address it and I ran out of time in my first presentation. There is no unlawful delegation in this case because since 1874, there's been a shift in our state constitution that moved the primary responsibility or the responsibility for public education from the General Assembly to the state as a whole. And as Justice Womack mentioned, we are living in a post-Lakeview world where that seminal case recognized that the voice of the people in Arkansas determined that they wanted public education to be an entire state responsibility, and they indicated that desire through an amendment in 1874 that made public education an entire state responsibility. There can't be an unlawful delegation to one department when every state department, as this court recognizes in Lakeview, is responsible for ensuring that Arkansas children receive a suitable and adequate public education. I want to address, I think Justice Hudson's question about the recent plan board decisions. Those decisions aren't applicable here. The question in those cases was whether the legislature has attempted to abdicate or entirely transfer to another body essential legislative functions. That's not what has happened here, respectfully, Justice Hudson. The General Assembly has promulgated rules, has set out a statute and provided the ways in which the state board provides support to public school districts and gives them the authority to exercise broad discretion, something this court has already held is lawful. And so this court's decision in Fitzgibbon, coupled with the observations in Lakeview, indicate that the state is not exercising legislative authority and there is no unlawful delegation. I also want to address Justice Hudson, or I can't remember Justice Wood's question about whether or not a reconstituted school district is subject to the AESAA, and I think appellees conceded that it is. And with that concession, there can be no other conclusion other than these limitations are expressly provided for by the statute. Appellees continue to say that these limitations are not provided for in the statute, and Justice Hudson, they simply are.
Ms. Hodge, the response that I received from opposing counsel was that there was something of a timeline or an order in which these things happen as per the statute. How do you respond to that?
There is a timeline and an order, and at the end of 5 years, the state does have to make a decision. But when you read the language in 2917, where it authorizes the state board to reconstitute the public school district under Section 613-1401, which applies to annexation and consolidation, and this subchapter. That is the authority that brings into play those express limitations of duty, the changes to the state board, and makes those applicable to the decision to reconstitute. And so they are.
So you're also pointing to 615-2917 subsection B3B.
2917 B3B.
Yes, the state board may limit the powers and duties of the public school district board of directors under 620 or any other law, but allow the public school district board of directors to operate under the direction and approval of the commissioner, and in this instance, Johnny Key.
Yes, Your Honor, and I would also like to point out that in that same section, the legislature makes reference to Arkansas Code annotated 613-620. And if you go to that section, those are the list of duties applicable to boards. And they do include things like personnel policy, contract negotiation, hiring and firing of a superintendent. These particular limitations are specifically referenced in the AESAA under the limitation of powers, and they are implicitly incorporated by pulling in and referencing 613-620. Even if they weren't expressly indicated, and they are, that's the state's initial position. Fitzgibbon says when the legislature gives the state the authority to take any necessary and proper action allowable by law. And the appellees haven't argued it's unlawful to require consistency with the superintendent, that exercise of discretion is not ultra virus.
Counsel, could you tell me, because I think one of the concerns is, so the Little Rock School District School Board, the prior board, could not bring students to the level where they could achieve. And then the state has tried for 5 years and has not brought students to the level where they can achieve. And it's just an abysmal failure on everyone's, for, a decade probably or more. So now there's this reconstituted board, but there's limits on it. What does this reconstituted board, what can it do with these limits to bring students up to standards? So to ensure that this is not just a pretense that we've, I think Mr. Nolan is, partially arguing that you're saying you're reconstituting, but you're not really doing it because you're holding so much authority still. What can they do with the authority, with these limits that could improve the students' academic standards?
Well, one, their primary responsibility, which is mentioned specifically in the reconstitution plan, is that they can operate and exercise the day-to-day functions applicable to a state board, only with the exception of these three limited. They can do everything else other than these three things. They can work with the schools and the superintendent, the leadership, to ensure that they can meet the exit criteria. They aren't permitted from working with the superintendent, from working with the specific schools mentioned in the exit criteria to ensure that they have a collaborative, effort to meet the goals as stated in the exit criteria. None of these limitations.
And I understand, but the superintendent and the Department of Education could have been achieving that for 5 years. So, what can this local school board, can you give me something specific that they can do with these limits to improve academic standards?
And I guess my answer is these limitations don't prevent them from working towards demonstrating that they no longer require level 5 intensive support. And I don't think the appellants even argue that the limitations prohibit the local board from working with the individual schools to demonstrate that they no longer need level 5 intensive support. Their argument is they aren't expressly bound in the statute. And they absolutely are, as I discussed with Justice Hudson. And even if they weren't expressly bound in the statute, the the phrase "to take any and all necessary action" would encompass those limitations, but the appellees don't argue that this prohibits them from prohibits the board from working with the school district and the individual schools to demonstrate adequacy and their ability to meet the criteria in the exit plan. Their argument is something different, Justice Wood. Their argument is we weren't given an opportunity to give our opinion about the exit criteria, and the law doesn't require that. Number one, it's not a rule. Number two, the General Assembly and the AESAA rules require the department to work with the district's leadership. And at that time, it's the superintendent, Michael Poore, that works with the state on the exit criteria. The appellees have no right under the law or the rules to give any opinion about the exit criteria. And so that doesn't demonstrate that the state is acting unlawfully.
Okay, thank you.
Yes, Your Honor. Just very quickly, I see that I'm out of time. If I may have 1 minute to wrap up, address one other thing and wrap up, Justice Kemp.
Since you've been responding to questions, that'll be permitted. 1 minute then.
Thank you, Your Honor. I just want to address two things very quickly. Justice Wood, you asked Mr. Nolan if he really wanted the court to read the statute his way. And under the standard of review, the appellee's interpretation of the statute is given no weight. Number two, Mr. Nolan attempted to distinguish the Fitzgibbon decision by pointing out that that case involved the beginning of a state takeover rather than the end. And that's a distinction without, a real meaning. The underlying principles giving the state broad authority and the holding that sovereign immunity bars this cause of action is still applicable here. And so for those reasons, the state would ask this court to find that the appellees have failed to demonstrate an exception to sovereign immunity, that were not required to promulgate local or rules related to the Little Rock School District, and there is no unlawful delegation of authority where the statute requires the state as a whole to assume the responsibility for adequacy in public education, reverse the Pulaski County's order denying the state's motion to dismiss on sovereign immunity. Thank you.
Okay, that concludes our oral argument this morning. Thank you, counsel. And for the justices, let's plan on conducting our case conference in 15 minutes at 10 minutes after 11. And court will be adjourned then. Thank you.